Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and you're right. You just never use it.
All present. Session 2 of the Walker Moot Supreme Court in the BLG courtroom is now in session. We would like to acknowledge that we are speaking to you from the traditional unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin peoples and all indigenous peoples in the region of Ottawa who call the national capital their home. If you are not located in Ottawa and do not know about the traditional territory on which you are located, we encourage you to navigate to websites like nativeland.ca to find out, and we also encourage that you learn more about the decolonization by consulting the TRC call to action as a starting point. It is with great honor and privilege that I present Justice Christopher A. Fizio Siskins, Katie Stiles, Gowling WLG, Justice Sarah Marzuk, the Walt Disney Company, Justice Omar Al-Radai, Fleet Street Law, Justice Sakina Babwani, Bennett Jones. On October 19, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health, 13 hours after a transfer from West Valley Memorial Hospital. Ms. Stark's medical records reveal she was in perfect health and she had no previous existing medical conditions, nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Ms. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5, Ms. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled, but the same day, Ms. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital where she was placed under the care of Dr. Myrtle Papadoulos, a third-year medical resident. Ms. Stark immediately requested Dr. Papadoulos administer ivermectin her family physician had prescribed, a course of treatment which he chose to reject. On October 6, Ms. Stark was moved into the ICU and placed on nasal cannula during the day and BiPAP at night. Ms. Stark was treated with the hospital's COVID-19 protocol, which consisted of dexamethasone and pure oxygen. On October 7, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadoulos. Within 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Luthier, chose to withhold any further administration after being informed of Dr. Papadoulos' use of ivermectin. On the evening of October 8, Ms. Stark's condition worsened, and she was sedated, incubated, and put on a ventilator. Almost immediately thereafter, Dr. Luthier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered, in addition to Math Plus protocol. In response, Dr. Luthier asked Dr. Strange to forward him the relevant literature for which she was relying on, so that he could make a rational and educated decision, which was provided immediately after. Dr. Luthier determined this time would be better spent attending to his patients than reading what he referred to as propaganda. On October 10, ICU nurse Dolores Patel was convinced by Ms. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the frontline COVID-19 critical care lines Math Plus protocol. Nurse Patel spoke with the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Miss Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process trying to bring her out of her medically induced coma. On October 11, Miss Stark's condition had improved, at this point having only to rely on a nasal cannula. On the morning of October 13, Miss Stark's family was informed by Nurse Patel that the hospital misplaced ivermectin, but there was no need for concern, as Miss Stark's was now making great progress. However, Dr. Lutze once again assumed care of Miss Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the Math Plus protocol. Dr. Lutze then administered remdesivir to Miss Stark. Nurse Patel phoned Miss Stark's family and informed them that Dr. Lutze had assumed care and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of an initiative to help provide critical care to patients battling COVID-19 in rural communities. At 1:27 a.m., Ms. Stark's oxygen level began to drop and she became unstable. Within 3 hours, Ms. Stark was again placed on the ventilator. The family arrived at the hospital, but was denied access due to the hospital's COVID-19 protocols in place. Mr. Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Lutze, but after 4 unsuccessful phone call attempts, decided to drive down to the defendant's hospital in an attempt to manage the situation in person. Upon her arrival, Dr. Strange was too denied access to Ms. Stark, and was unable to speak with Dr. Lutze. Within 6 hours, Ms. Stark's chance of survival had dropped down to 20%, and Dr. Lutze informed Mr. Stark that he had exhausted both his course of treatment and COVID-19 protocols in treating Ms. Stark. Mr. Stark pleaded with Dr. Lutze to administer the Math Plus protocol and offered to sign a release, releasing Dr. Lutze and the hospital and any of its agents and parties acting on his behalf from any and all liability arising from administering the Math Plus protocol to his wife. However, Dr. Lutze refused to administer the Math Plus protocol, and a verbal confrontation ensued outside between Mr. Stark and medical staff, and security removed him from the building. On October 19, Dr. Lutze agreed to transfer Miss Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to resume care for her. However, less than 1 hour after arriving in Fallview Health, Miss Stark died. In this matter, the questions at issue are the following. Issue A, standard of care. 1. What is the requisite standard of care for medical negligence in Canada as correctly applied to this case? 2. Did Dr. Lutze breach the standard of care in A, failing to investigate the literature he was provided with, and B, denying Ms. Stark treatment with Math Plus or ivermectin alone? Issue B, causation. Did Dr. Lutze's conduct cause or contribute to the harm of injury Mr. Stark sustained? Issue C, vicarious liability. Is the hospital vicariously liable for Dr. Lutze's actions? Justices of the panel, I present to you, speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Gabriel Guizzo and Cassandra Eva. And speaking on behalf of the defendant, Dr. Lutze, and the West Valley Memorial Hospital, Alexander Ruigrok and Andrada Marinescu. We're here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Lutze, and the West Valley Memorial Hospital. Both the plaintiff and defendant's counsel will have 30 minutes each in total, 15 minutes each counsel member to present their arguments to this court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they choose. I will signal to the court when there's 5 minutes left per speaker. The court now invites counsel for the plaintiff to begin.
Thank you. Good morning, justices. Again, for the record, my name is Guizzo, first initial G, and my co-counsel's name is Edie, first initial C. And as has been stated, we are representing the plaintiff, Mr. Stark, and we take the position that Dr. Lutze was grossly negligent in his care of Mrs. Stark by denying her access to an alternative life-saving treatment known as Math Plus protocol and ivermectin. To begin, I will briefly touch on the duty of care and then address one of our primary issues, the breach of the standard of care. Next, my co-counsel will speak on the causation aspect of our negligence claim and the vicarious liability of the hospital. Lastly, I would like to reserve 3 minutes for a rebuttal after the submissions have been made. To begin, with the duty of care, this is an uncontested matter. It has been well established in case law that there is a fiduciary duty between the patient and the physician. In McInerney and McDonald's, the Supreme Court of Canada held that the relationship between a physician and patient is one in which trust and confidence must be placed in the physician, and further stated that the duty of the doctor is to act with the utmost good faith and loyalty. So what does this mean? This means that the patient's needs are the first priority of an attending physician. It means that when a doctor is reassuring the patient that they are doing everything they can, that they are actually doing everything within their powers to save their patient's life, especially one who is scared and left to die alone because of hospital COVID protocol. This is not what happened in Mrs. Stark's case, who had the option of a safe, alternative, life-saving treatment, the MAP protocol, but was denied access, not based on invalid medical evidence, but on personal bias of her attending physician. MAP protocol.
I'm hoping we can move to the standard of care. I think
Yes.
that's the main issue and dispute here.
Of course. Okay. Yes. So in the standard of care, we focus on 3 aspects. And so before I get into those, I'm going to just cover that the standard of care for a physician was found in Ter, Knutson, and Korn. And in this, they held that the physicians have a duty of conduct, their practice in accordance with the conduct of a prudent and diligent doctor in the same circumstances. So in these novel times, what would a prudent and diligent medical doctor look like? First, we hold that a prudent and diligent medical physician would have investigated the literature that was provided by him, by Dr. Sophia Strange. So during the discovery examinations, all the doctors, including Dr. Lucier himself, stated that they would take the time to read the literature, especially if it meant that it came from another well-respected medical professional of equal or greater credentials, and if it could save a patient's life. Dr. Lucier did not read the literature that was provided to him by Dr. Strange. Instead, he dismissed it as anti-vax propaganda. Dr. Strange is not some fringe conspiracy theorist. As I've stated, she's a well-respected doctor in the medical community who specializes in epidemiology and has extensive knowledge of the use of ivermectin and provided a plethora of high-quality medical research, which again, as I stated, he dismissed as propaganda.
Okay, so counsel, what I'm curious is because the defendants also rely very extensively on Terneuzen and indicate that the physician involved met the requisite standard of care because they were following evidence-based medicine. And so how can you explain the discrepancy between the 2 different approaches and relying on the same case?
Yeah, so also in that same case, the judge has stated that even if a standard practice, fails, to adopt an obvious and reasonable precautions, which are readily apparent to the ordinary finder of fact, then there is no excuse for the practitioner to claim that he or she was merely conforming to such a negligent common practice. So essentially saying that, yes, this is how we do things, this is, how possible protocol operates, is not a justifiable excuse if a justifiable reason, if the finder of fact can agree that, more reasonable actions should have been taken or precautions. And in this case, we argued that there was more reasonable actions that should have been taken, and that was not what happened in this circumstance.
And so why is it more reasonable to embark on a novel experimental regimen?
So in this, there's actually quite a significant amount of research. And in this case, she did provide there's about 64 studies on ivermectin itself, and 32 of them are considered to be randomized controlled studies, which is considered to be some of the highest standard in the medical field. And I think any kind of treatment that, we're going through here is considered novel, but off-label drug prescriptions is not uncommon. Dr. Lucier himself has done so frequently in the past. And these are all FDA approved drugs and vitamins. So it's not like we're asking him to use something illegal or that just came out into the market.
And just going back to your comments on standard of care. So Dr. Strange is an epidemiologist, correct?
Yes.
And Dr. Lucier is a critical care physician, correct?
Yes.
Aren't those 2 different specialties?
They both encounter infectious diseases within their job frame. She also does work in an ICU ward where she does treat COVID patients as well. So she does kind of operate in this same circumstance as Dr. Lucier as well.
But they have different training, isn't that?
Epidemiologist
is not the same?
Oh, sorry.
No, I was just going to say, so an epidemiologist, the training compared to what Dr. Lucier went through, isn't the same, correct?
It could vary. I think every doctor, varies in their training. No doctor has the exact same training. She just has actually more knowledge in the area of infectious diseases than he would.
And isn't it, and correct me if I'm wrong, with the case law that for standard of care, the court is to look at what a reasonable physician in Dr. Lutzier's specialty would do?
It is held like what a reasonable doctor. There is options. There's the ability to look like what a reasonable doctor. Yes, it would be within his specialty as well, but they both operate in the capacity as an ICU doctor. So if we're looking in the capacity of an ICU doctor, which they both do work as a doctor in the ICU, that's the standard how I have particularly held it. ICU doctors who are treating COVID patients. And this is kind of the standard, the criteria that we're laying out is the qualifications the standard that we're trying to adjust that should have been met for ICU doctors treating COVID patients.
Okay, and one more question, then I'll let you get on. So if the court finds that the standard of care is that a physician should review research sent over by a fellow colleague, what's the standard if the physician disagrees with that research?
Yeah, so if the physician does disagree with that research and provides justifiable medical reasoning that based on this that he doesn't want to do such procedure, obviously it's within his right and capacity not to go through medical procedures that he feels could cause further harm to his patient. But that's not what happened in this circumstance. He didn't read the
Okay,
literature.
I'm going to stop you there. So what I understand is you're saying it's a judgment call once the physician reviews the research.
Yes.
Okay, so do you know what the case law is on a judgment call for a physician?
Not offhand, no.
Okay, all right, keep going.
Second criteria of a prudent and diligent physician would be that they've ensured that they've had informed consent. And so if we look in the Cuthbert and Rizzoli case, the patient's consent must be given voluntarily and must be informed, which requires physicians to ensure that a patient understands the nature of the procedure, its risks and benefits, and the availability of alternative treatments before making a decision about a course of treatment. This did not occur. Ms. Stark repeatedly voiced that she was not being listened to, and her family was not actively being informed about the medical treatment she was receiving. The hospital had not given the treatment protocol to the family, and other medical professionals were discouraged to talk to the family, including Mrs. Stark's husband, who was her POA, her power of attorney. This is a gross breach of the standard of care, and we believe is inexcusable for a doctor of his experience. His reasoning is that of why he wasn't informing the family to his full capacity was that they were too uneducated, and in this reasoning, we believe it is obviously in itself is not just as an absurd statement to say that you're not going to inform a family because they're uneducated when they themselves are actually a family of doctors. No alternative treatment such as mouth protocol was discussed between Dr. and Ms. Stark or Ms. Stark's family. And so allowing a physician to make a unilateral determination whether consent is required in any given case, cuts against the patient autonomy and the statutory objective of providing consent rules that apply consistently throughout all settings. So ensuring the active lines of communication is obviously very critical between a doctor and a patient, or if the patient is unable to speak or advocate for themselves, between the patient and their power of attorney. This did not happen. The family was not able to have discussions when it came to anything with the mouth protocol, even with Dr. Strange. And when when the family had the opportunity to have discussions with doctors about the mouth protocol and was able to provide them with knowledge and research on that for them to make their own determination, they did end up using math or adhering to math or ivermectin, and Ms. Stark repeatedly showed signs of immense and rapid improvement. Our last point of a prudent and diligent doctor would have been to not have delayed the transfer of a patient knowing that they had exhausted all the options within their capacity, and then another doctor was offering a life-saving alternative treatment that they had proven to have found effective in their hospital capacity of the ICU. Dr. Lutsier stated that he had exhausted all his options when saving Ms. Stark. Yet, he refused to transfer Miss Stark to Dr. Strange for 6 days. When a highly competent and experienced doctor says they have an alternative treatment, such as math protocol, but they have found effective in their hospital. And when a patient is ICU, each minute is crucial, and an experienced ICU doctor should know that. His concerns that it could lead to renal failure or the alternative treatment would not work is unjustifiable when the alternative outcome in his care is death. But before I conclude, as a final statement, I'd like to make that justices, today we're not asking you to obviously make any scientific determinations. You are being asked to analyze the grossly negligent conduct of Dr. Lucier, who went against the standard of care in his treatment of Ms. Stark, not because he is incompetent, but because he let his personal prejudices and biases delegitimize reasonable alternatives of healthcare that would have saved Ms. Stark's life, all because it is socially acceptable to denounce any medical evidence that is contrary to the opinion of government agencies, that is without reasonable justification, that society has deemed to make these agencies infallible, and the reasoning is such. And now there is a child who will learn how to walk, talk, and grow up, all without his mother. Upon no further questions, these are my submissions.
Council, I think we have a couple minutes, so maybe you can explain to me where we draw the line, because it sounds as if we adopt your submission that physicians would have to cater to any type of evidence and not their own experience or the preponderance of evidence or guidelines that are used in their particular specialty. How should a physician deal with new, at the very least it's new, if not novel, type of evidence?
Yeah, that's definitely a complicated and not an easy answer. And that's something I think we've been trying to figure out. We're always getting new information and trying to keep up with medical research. And I think with that, we need to, what I would consider is to weigh, certain medical research and evidence. So ivermectin and math is definitely one of the more forefront, considered to be very contrary, great opposition, has been referred to by these government agencies to the use of it. But as it is tough, I think asking them to read, a study or two is not a lot, especially since there is a lot of talk and medical research around it. I think if there's enough, and this was a tough question, but if many of the doctors within our discoveries have said if there's a significant amount of research supporting it, some have certain numbers, so it very depends on the doctor, but if there's an X number amount of studies regarding a certain study that and it's being presented to them, that a doctor should consider reading one of the studies if it's presented and it may be believed as a potential option by another well-respected doctor that it could save their patient's life. So I think in this we have to look about, is there a significant amount of high quality studies out there? And is it something being recommended by also doctors of the same caliber as them? So I think that should be two factors a doctor should consider when determining if they should continue doing some research on something, as well as the patient, if it could save a patient's life, of course.
The court now invites co-counsel to present arguments.
Thank you. Good morning, justices. I thank my co-counsel who has addressed the first two parts of the negligence claim by establishing the existence of duty of care through our factum and demonstrating that Dr. Lucier's conduct breached the applicable standard of care owed to Ms. Stark. So I will now be turning to the issue of causation to demonstrate that the defendant caused the damage, so the death of Ms. Stark. And lastly, I will be turning to the issue of vicarious liability of the hospital. So Clements and Clements 2012, Supreme Court of Canada, paragraph 8 summarizes the but-for test for causation. I quote, "The test for showing causation is the but-for test the plaintiff must show on a balance of probabilities that but for the defendant's negligent act, the injury would not have occurred." So in other words, as the plaintiff, we must establish that the breach of the standard of care more likely than not caused the plaintiff's injury, the tragic death of Ms. Stark. So what I'll be doing is I'll be going through all three of the defendant's failures to meet the accepted standard of practice as outlined by my co-counsel, and then demonstrate how on that balance of probabilities, the breaches did result in the adverse outcome.
Before you do that, counsel, I'm wondering if you're going to be able to touch on this notion of causation as explained by the Supreme Court of Canada in Fraser, because this is referred to by your friends in their factum, and I'm hoping you're going to be able to touch on that as well.
If possible, if I could get back to that a little bit later, is that okay?
I think that is a question of interest to the bench, so as you wish, counsel.
Okay, thank you, Justice. So first, when Dr. Lutzier refused to investigate the relevant literature on COVID-19 treatment options, this caused delays in alternative life-saving treatment. So Ms. Stark's chance of survival when she entered the hospital was at 90 to 98%. Yet under Dr. Lutzier's care, there is really only clinical evidence that Ms. Stark's condition worsened. Towards the end of Ms. Stark's life, her chances of survival were, dropping to 20%, and Dr. Lutzier still refused to consider other options. So really the clinical evidence shows that there was a beneficial alternative treatment. Ms. Stark had demonstrated positive outcomes, and she responded well previously to Math Plus and ivermectin when administered by previous doctors and nurses. And I think that clinical personalized data there is really important in terms of the causation factors. Yet Dr. Lutzier withheld those treatments from her, which caused her health condition to simply deteriorate. So for example, Ms. Stark's condition had improved to the point where she was only relying on a nasal cannula at one point, following that Math Plus and ivermectin administered by previous physicians and nurses, but then worsened once it was withdrawn. So I think Dr. Lutzier's failure to investigate that literature and inform himself led him also to administer remdesivir, which also caused instability in her condition. So there are a lot of factors here that demonstrate that Dr. Lutzier and his failure to investigate that literature and inform himself caused a deterioration in Ms. Stark's condition, leading to her death.
Counsel, I'm going to interrupt you right here. So I understand that one of the risks of Math Plus, if it's not let me take that back. Math Plus needs to be started at a specific time in order to be effective, correct?
Correct, yes.
Okay. And one of the risks of Math Plus is the patient ending up on mechanical ventilation, correct?
Correct, yes.
Isn't that what happened in this case? Multiple times.
Yes.
Okay, and so let me ask my next question. So what is the plaintiff's expert evidence that Ms. Stark going on mechanical ventilation is not due to the Math Plus?
So based on the facts that Ms. Stark was on a ventilator prior, it wasn't right after it wasn't very soon. The evidence shows that she actually improved right after the Math Plus. And I think there's a factor in between there that we also need to consider, that administration of the remdesivir, which based on the evidence can also lead to renal failure and severe outcomes. And that was still administered, which on a balance of probabilities would have led to a deterioration. And
so let me just understand. So, and just going back to my question, is there any expert evidence saying that the mechanical ventilation that the plaintiff, that Ms. Stark was placed on sometime early hours of October 14th was not a result of Math Plus?
There is no scientific evidence on that.
Expert, I'm sorry, expert.
Sorry, there is no expert evidence on that. However, I think we do need to consider that she was left on a ventilator for 6 days without, with Dr. Luthier not being open to any other treatment options. And I think that delay is really the standard of care that was breached that we're looking at in terms of causation as well.
One last question, then I'll let you continue, is what is the plaintiff's position on when Ms. Stark should have been placed on Math Plus?
Our position is that the patient requested Math Plus early on. So, and in order for the treatment to be effective, it had to be administered as early as possible.
And what's the time, and what date was Math Plus first requested?
I don't have that right in front of me.
Okay, carry on.
Yeah.
That's okay.
Thank you for your questions. October 6th, apologies. So Dr. L's bias towards certain treatments, literature, and towards a well-respected doctor did lead to a failure to consider other possible treatments, which on a balance of probabilities caused Ms. Stark's death. And second, we want to look at that failure to obtain informed consent from the patient as well, which caused worsening in the patient's prognosis as well. Ms. Stark had a right to refuse medication, which was overwritten by Dr. Luthier without reasonable justification. And the medicine he administered without her consent, remdesivir, the largest side effect is acute renal failure, which he did disclose in discovery. So following the administration of remdesivir, her oxygen level began to drop and she became unstable. So, that consent, the consent is important. It's hard to believe that a doctor who doesn't respect the foundations of healthcare and consent, could not have caused the death of Ms. Stark, who was under his care. There is case law demonstrating that, where a fault is present and a clear presents a clear danger. And I think that failure to obtain consent is a clear danger. It's the foundations of healthcare. Courts have reasonably presumed a causal link in those circumstances.
I've got a question for you. Did Ms. Stark develop kidney failure?
No, but there was that risk.
But that risk did not materialize.
No, but causation needs to be looked at broadly and as a whole, and doesn't require that kind of scientific evidence and precise contribution according to case law. So I'm
going to stop you there. So what evidence, and let me go back one step. Is the plaintiff arguing that the administration of remdesivir caused Ms. Stark's death? Or is it the failure to administer the Math Plus protocol?
So it was the failure to administer the Math Plus protocol in this case.
Well,
but the remdesivir comes in terms of, the standard of care, the multiple breaches of standard of care that altogether, caused the death of Ms. Stark.
But, and that's what I'm trying to understand is what did the remdesivir cause if she didn't go into renal failure?
Yeah, thank you for your question, Justice. Yeah, so causation is just, I'd like to reiterate, it's not it's not an issue of precise scientific causation, right? It's you need to look at it as a whole and broadly.
Keep going. Thank you.
Thank you, Justice. So third, my co-counsel also touched on the transfer between hospitals, and how Dr. Lutzier didn't transfer Ms. Stark to a hospital with an equally qualified medical professional who was offering that alternative treatment. And as stated earlier, for Math Plus to be effective, timing is critical. And Dr. Lutzier did cause, a reduction in effectiveness of Dr. Strange's administration of Math Plus by waiting to transfer her. So instead, Mr. Stark just said that he exhausted all treatment and COVID protocol, and left her there without any solutions.
Counsel, isn't it likely though that the outcome here would have been the same regardless of the intervention?
So our position is that no. I think that's an assumption, and that the standard of care was breached and ultimately led to her death. So based on the evidence and the expert testimonies on how effective Math Plus has been and has not resulted in deaths for many patients, I don't think that's a fair assumption to make. So if the court is satisfied, may I continue?
Yes, please.
Yeah, so just our conclusion on causation is that based on the evidence put forward, we, the plaintiff, submit that on a balanced probabilities, but for the breaches of the standard of care, Ms. Stark would still be with us today. Keeping in mind that case law has suggested that in some cases where fault presents a clear danger and where such a danger materializes, it can be reasonable to even presume that causal link. So now onto the issue of vicarious liability. We do submit that the hospital is vicariously liable for Dr. Lutzier's actions. At common law, the principle of respondent superior means that health facilities will have vicarious liability for their employees. The relationship between health facility and health professionals make it clear that the facility will be vicariously liable for the conduct of health professionals. And it is our position that it's quite clear that Dr. Lutzier is an employee of the hospital as opposed to being an independent practitioner, based on the employment agreement, which stated that the hospital employs Dr. Lutzier.
So counsel, nobody's disputing that he is an employee, but how are his actions here so closely connected to the role that the hospital has authorized him to do that we would attach liability, perhaps under a Baisley analysis or some other test that you might want to submit?
So our position is that like the negligence did occur within kind of the scope of his employment, because the unauthorized act of we don't really see like the scope of employment as an issue here. He acted within the tort did occur within the scope of employment based on the evidence that we see.
Thank you, counsel. Just keep an eye on the time. The court now invites the counsel for defendant to present arguments.
Thank you, Justices.
Good morning, Madam and Mr. Justices, and good morning to our friends, and we thank you for your submissions today. My name is Andrada Marinescu, and I'm here to represent the defendants. A co-counsel and I are here today to bring to light the true nature of Dr. Lutzier's care for Ms. Stark, well-informed and evidence-based. We therefore submit that Dr. Lutzier should not be found liable for negligence for his care of Ms. Stark, and that West Valley Memorial Hospital will not be found vicariously liable, even if Dr. Lutzier were to be found negligent. To do this, we'll start off with a brief opening statement, after which we'll dive into our main submissions, which will comprise of 4 main parts in the following order. Firstly, I will submit that Dr. Lutzier's requisite standard of care as correctly applied to this case is that of an ordinary specialist in the same field, possessing a reasonable level of knowledge, competence, and skill. And secondly, I will submit that Dr. Lutzier adhered to the standard of care in his care for Ms. Stark. Followingly, my co-counsel will take the lead to explain the issues of causation and the issues with Dr. Strange's and our plaintiffs relying on faulty research in support of ivermectin. Lastly, we will also discuss the issue of vicarious liability of the hospital. So to begin with Dr. Lutzier's standard of care, we note that the duty of care that is a prerequisite finding for the overall finding of negligence is not an issue today. This is because it is well established in the jurisprudence. We agree with our friends in the ordinary specialist requisite standard of care, and we submit on the same authority of Terneuzen v. Korn. However, we submit that in Dr. Lutzier's specialty of pulmonary and critical care medicine that reflects the standard of care, and in the context of treating COVID-19 patients, this requisite standard of care manifests into a duty and obligation to treat COVID-19 patients, such as Ms. Stark, with the approved treatments employed by other average and ordinary specialists in pulmonary and critical care medicine. This inherently—
So, counsel, how would you respond to your friend's submission that regardless of the formal specialization of the physicians, they were functionally performing similar or comparable type of care within the ICU?
Thank you so much for your question. We submit that critical care medicine is employed in the ICU, and as well as ventilators being used. This represented his specialty in pulmonary medicine. So we do not believe that there is a discrepancy between his standard of care regarding his specialty and training versus how he was performing. And if you are referring to the specific nature of his duties being an attending physician is responsible for the lower hospital staff, and therefore he should not be regarded as a lower standard of care because he was performing duties that were below his higher position in other times. If this satisfies your question, I would love to move on to the rest of my submissions. We respectfully submit that this is the correct standard of care because it is grounded in well-established jurisprudence by Canada's highest court and Ontario's highest courts as well. And Madam and Mr. Justices, I will now explain to you how and why Dr. Lutzier adhered to a standard of care when treating for Ms. Stark. We respectfully submit that the 2 claims brought forward by the plaintiffs before this court today per page 8 of our moot package are the 2 following claims. Firstly, that Dr. Lutzier made a judgment call to attend to his patients instead of embarking on investigation of Dr. Strange's email and documents. And secondly, that Dr. Lutzier adhered to the hospital's COVID-19 protocol treatment instead of experimenting with ivermectin and Math Plus. Our overarching argument as to this adherence is that Dr. Lutzier acted in conformity with a respectable medical community. At paragraph 51 of Terneuzen, Justice Sopinka of the Supreme Court held that a doctor will not be held liable for negligence if he acted in conformity with a recognized practice of his profession. This is an elaboration of the standard of care we established and not a way for a doctor to avoid negligence.
And so, counsel, how does the client's preferences, autonomy, choices as it relates to their own care fit into that?
That would fit into the issue of informed consent. And with respect to Dr. Lutzier acting in conformity and a patient's autonomy fitting into that, we respectfully submit that the issue of informed consent was not brought before the court today. And while we would love to expand on it further, I would love to focus on the issue of acting in conformity as respect to the two claims brought before this court today in terms of investigating the evidence and the treatment administered to Ms. Stark.
Okay, I'm actually gonna jump in at this point. So going to your point of what you want to focus on is whether Dr. Luthier met the conformity of the standard. The defendants argue at what I understand, paragraph 34, that the court in part should not accept Dr. Titchener's expert opinion because it's based on what he would have done in that situation. Do I understand your argument? Okay.
Yes.
But isn't that how we find out what the standard is what an expert would have done in that situation?
Thank you so much for your question. I would love to address this point. So our submission relying on Bogoroch is that a court should not rely explicitly on an expert witness's personal views in a situation, and rather should rely on an objective submission on what the standard of care should have been in that case. So therefore, we would encourage the court to rely on established jurisprudence by the Supreme Court as to the standard of care, instead of our expert witnesses' specific statements as to the standard of care today. And there are specific reasons why our expert witnesses do not make credible statements as to the standard of care. First of all, for Dr. Titchener and Dr. Moriarty are two expert witnesses here today, even though we have depositions from Dr. Strange and Dr. Luthier. But starting off with Dr. Titchener, he's unable to refer to any credible scientific literature and stating that Dr. Luthier's administration of the hospital's COVID-19 treatment is medically unsound. And he makes this statement as argument that his standard of care was breached. So therefore, we submit that his statements were not credible. Secondly, he misconstrues the factual situation that Dr. Luthier was in, as he states that Dr. Luthier was sitting there watching Ms. Stark die and was uninformed in his treatment. And we respectfully reject this because Dr. Luthier was not sitting there watching Ms. Stark die, as he was attending to patients in the critical unit, including Ms. Stark, realizing that she was not being treated with the hospital 19 protocol. And also he was not uninformed for two very important reasons. First of all, he was responsible and participated in the team that designed the hospital COVID-19 treatment plan when the pandemic came upon the hospital and the world. And this includes a regular and frequent review of all the most credible literature and in designing this COVID-19 treatment plan. And secondly, Dr. Luthier was aware of the contents of the email that he was sent when Dr. Strange contacted him before emailing him. So therefore, he was aware of the contents, and he inevitably would have been informed on ivermectin and Math Plus in his regular and frequent research and participation with his team. And therefore, he made an educated and informed judgment call in choosing to ensure the administration of the hospital's COVID-19 protocol and attend to his patients instead of opening the email. And I believe I may have lost the original direction of your question, but please feel free to clarify in your question.
Yeah, so my original question was, and I'm going to take you to another part in your written argument because it goes back to what I was asking earlier about paragraph 50 of the defendant's written argument. The defendant relies on the expert opinions of the defendant physicians in Rizzulli to argue that Dr. Letzier met the standard of care, correct?
I'm sorry, could you repeat that?
Sure, so I'm going to take you to paragraph 50 of your written argument.
Yes.
All right, and so halfway through the paragraph, it reads, in that case, the defendant physician's expert opinions to withhold life support were not questioned by the court as they reflected, quote, a widely accepted view in the medical community, end quote. This precedent affirms that the defendant met the standard of care by adhering to a protocol based on evidence-based medicine accepted by the medical community. So my question is the defendant relying on expert opinion in a different case to say that Dr. Letzier met the standard of care?
Yes, because this case has, sorry.
Okay, and so then it goes back to my original question isn't relying on an expert standard practice like Dr. Titchener the way the court figures out what the standard of care is?
Thank you so much. Well, in this case, as this case has not been decided yet, it is up to the court to act as a trier of fact in considering expert witnesses to decide on the standard of care. However, referring to jurisprudence where expert witnesses have been used before are now, we consider established jurisprudence and have more of a binding effect on the court today.
Thank you.
Thank you. Okay, 5 minutes. Okay, thank you. So just to summarize our overarching argument as to why Dr. Lutsier adhered to a standard of care. So first of all, as I mentioned, the two very important reasons that establish that Dr. Lutsier was sufficiently well informed to be able to make his educated judgment call and choosing to attend to patients instead of doing research at Dr. Strange's will is based on the fact that he participated and was responsible for the COVID-19 hospital treatment and doing continuous research on strictly credible, peer-reviewed and high quality data, and therefore also rejecting less credible and not peer-reviewed data. And also he was aware of the contents of the email when Dr. Strange contacted him before emailing, and therefore he was able to make a judgment call based on his prior research. So to summarize, there was no need for Dr. Lutsier to read the documents to properly treat Ms. Stark. And as to the second claim of his ensuring the administration of the hospital's COVID-19 protocol, that again, we submit is Dr. Lutsier acting in conformity with the respectful medical community by nature of the fact that the protocol was designed on the basis of the most credible and peer-reviewed and well-regarded literature and data available to him at the time and continuously updated. As such, we summarize, therefore, that Dr. Lutsier's judgment call was not a breach of his standard of care and that his standard of care was that of an ordinary specialist in pulmonary and critical care medicine and assessed compared to other specialists, possessing a reasonable level of knowledge, competence, and skill. And again, by nature of his reliance on the most credible and up-to-date data on peer-reviewed research, he is conforming to the rest of the medical community that is the most evidence-based and therefore is acting in the most reasonable way by ensuring Ms. Stark was continuously having the objectively best treatment available at all times.
I'm curious, counsel, how we deal with this notion of evidence-based medicine when we are dealing with novel circumstances, novel situation. This pandemic, worldwide pandemic, is part of the factual matrix, I think, that we weigh things like expert testimony with. And so how do we actually look at evidence-based medicine in the context where the evidence may not be readily available?
Thank you so much for your question. I completely agree that it is quite the conundrum to have to continuously update treatments despite this ongoing pandemic. However, our submissions are Dr. Lutsier was very reasonable in the hospital and having a regular and up-to-date research team that was comprised by a wide variety of medical experts in pharmacology, research specialists, pulmonary and critical care medicine, among others. And therefore, the dilemma of having to stay up to date is addressed by having an implemented system to look at the most credible and peer-reviewed research. And we submit that it is a respectful medical practice and profession that looks at credible research and does not put too much trust into research that is not properly conducted, maybe is a rush study. It is their medical practice to rely on safe and evidence-based medicine, if that answers your question properly.
You may proceed.
Thank you. As I have summarized my submissions today, I would like to respectfully close off and allow my co-counsel to take the lead, subject to any more questions from anyone else or yourself.
Good morning, Mr. and Madam Justices. My name is Alexandria Ruigrok, and I'm co-counsel for the defendants, Dr. Justin Lutsier and West Valley Memorial Hospital. First, I will address the issue of causation, and our position is that Dr. Lutsier did not cause Ms. Stark's death. Next, I will address our alternative argument that West Valley Memorial should not be held vicariously liable. Should this court find Dr. Lutzeyer to have breached the standard of care, we submit that his actions were not the actual cause of Ms. Stark's death. Ms. Stark had already entered the pulmonary phase of COVID-19 at the time Dr. Lutzeyer assumed care, and her chances of surviving were therefore extremely low. While our friends have submitted that treatment with ivermectin or Math Plus would have saved Ms. Stark, we submit that these drugs have never been proven as effective for treating COVID-19, and as such, they could not have improved Ms. Stark's outcome. We agree with our friends that the appropriate test for causation is the but-for test as set out in Clements versus Clements. While the Supreme Court has consistently established that but-for causation does not require scientific certainty, it does require the plaintiff to establish on a balance of probabilities that the patient's death would not have occurred but for the defendant's negligence. We submit that the appropriate standard laid out in Clements and affirmed by the same court in Ediger versus Johnson requires that Ms. Stark's death would not have occurred but for a proven breach of the standard of care by Dr. Lutzeyer. This standard translates here into a requirement that ivermectin or Math Plus would have saved Ms. Stark's life, based on the claims brought here today. Per the Supreme Court's holding in LaFerriere versus Lawson, we submit that this court should consider any potential faults by Dr. Lutzeyer alongside other identifiable causal factors leading to Ms. Stark's death. In this case, COVID-19 is the uncontested cause of death of Ms. Stark, and we therefore submit that this court should carefully weigh any evidence presented by our friends alongside the well-studied progression of severe COVID-19 illness, which was evident from the moment that Ms. Stark presented to the emergency room at the defendant's hospital. Although Ms. Stark was a young, healthy woman prior to contracting COVID-19, she was unfortunately part of a small minority of COVID patients who cannot fight the virus. When she presented to the ER on October 5th, her infection had already progressed to the pulmonary phase. And by the time Dr. Lutzeyer assumed care, she had developed advanced fibrotic lung disease. At this point,
it appears as if there's also an incredible amount of variability in terms of not only how COVID-19 patients present themselves, but in terms of their response to therapy. And so what would you make of your friend's submission that that she was actually responsive to the therapy of her choice and her choosing?
Thank you for your question, Your Honor. Our response, the basis of our response to that question lies in the difference between correlation and causation. And so that phrase is thrown around a lot in scientific discourse, but it basically means that there are two co-occurring phenomena. And when you conflate correlation and causation, you attempt to attribute one phenomenon to the other phenomenon. And so our submission is that the up and down progression of illness that Ms. Stark experienced cannot actually surpass the level of correlation and be identified as a causal link, because observation of one person is insufficient to make that kind of determination, especially in the face of the scientific evidence that exists to date on ivermectin and Math Plus. And at the end of the day, our respectful submission is that the evidence is not in favor of ivermectin or Math Plus having any possible true causal link to any benefit in Ms. Stark. Does that answer your question?
If it didn't, you'll hear another question from me. So maybe you can tie that in for me to Fraser in Ontario, which you cite in your factum, and the Supreme Court of Canada's commentary then on causation as it should be used in law.
Certainly. So when we bring up Fraser Health Authority, it's really, I think that in our factum, when we mentioned Fraser Health, it was on the basis that the causal link should not be exclusively determined by expert evidence. And so our submission to that point is that the expert for the plaintiff in our respectful submission did not sufficiently establish the causal link, and therefore this court should rely on all of the evidence at hand rather than simply the presence of that single expert's opinion. And so we submit that this positive evidence from their expert should be taken in conjunction with all of the other evidence by this court.
So I'm going to jump in here with my follow-up question is, So I understand from your argument, we need to look more, we can't just look at correlation causation, but we should also not just be limited to expert evidence. So, the hospital chart, according to the hospital records, Ms. Stark became unstable after Dr. Lutzier provided her with remdesivir. Is there any, what is the defendant's position on that? How did that administration not cause her final decline?
Thank you for your question. So although remdesivir was not a part of the statement of claim or the moot package rather, we did a little bit of extra research on remdesivir just in case, since our friends had that submission. And so our friends' evidence that remdesivir caused Ms. Stark's decline was specifically a Health Canada advisory that was issued on August 21st. And we respectfully submit that this advisory warned of a potential side effect of sinus bradycardia from taking remdesivir. And I would point out that anytime a new side effect is discovered in a new drug, Health Canada does issue a safety advisory as part of the drug approval process in Canada. But this notice was merely warning of a small possibility that remdesivir might cause a slowed heart rate in some patients. Our friends also pointed out that their expert witness mentioned a potential side effect of liver failure, I believe. And to that point, I would respectfully submit that neither of those issues, neither slowed heart rate nor liver failure, were the cause of Ms. Stark's death. And if we were to look further to Health Canada advisories, I would respectfully submit that Health Canada has actually had a public advisory on ivermectin since prior to Ms. Stark contracting COVID-19. And that public health advisory actually says Health Canada advises that ivermectin is not authorized to treat COVID-19 and may cause serious health problems.
And just a follow-up question, because you referred to the plaintiff's expert evidence. Has the defendant presented any expert evidence with respect to causation?
No, so sorry, thank you for your question. The expert evidence that was presented in the deposition, so I guess I'll say first that the experts were Dr. Titchener and Dr. Moriarty. Dr. Strange was not an expert for this case today. We largely relied on the body of research that Dr. Lutzier was relying on in making his decisions, rather than the testimony of the expert witness. We found, based on the depositions provided, the experts did not speak to causation. They spoke more so to the issue of the standard of care and the breach. And just given the lack of available evidence that was found in those depositions, we chose to rely on them for the standard of care because that was what the experts were asked about by the members of our legal team from our firms.
Thank you.
Thank you. So in our respectful submission, the issue of causation in this case really hinges on understanding the true nature of the evidence in support of ivermectin and Math Plus. These drugs have never been approved or recommended for the treatment of COVID-19 by any reputable health authority, and the research supporting them is both biased and scientifically flawed. Our friends suggest that ivermectin could have resulted in a better outcome for Ms. Stark. As evidence for their point, they quote their own legal team's depositions comments and rely on the testimony of Dr. Strange. And on this evidence, our friends ask this court to bridge a factual gap and infer that Ms. Stark's death was caused by Dr. Lutzier's decision to not administer ivermectin. To that point, we wish to respectfully note again that Ms. Strange was not called as an expert here today, and that the evidence she uses to support her opinion is neither peer-reviewed nor supported by the scientific community at large. As such, we respectfully submit that Dr. Strange's opinion should not sway this court's decision on any issues requiring expert evidence. And we rely very heavily on the difference between correlation and causation here. And our respectful submission is that while our friends suggest that Ms. Stark's off and on progression of COVID symptoms are somehow linked to the occasional administration of ivermectin, she was administered ivermectin at one point and Math Plus at another. We submit respectfully that there is no reputable scientific literature to support this inference. Without applying the scientific method, these changes in Ms. Stark's condition cannot be turned into assumptions about how her illness might have progressed, correlation cannot be used to establish causation here today with a sample size of 1. And while we wish to respond to our friend's submissions that remdesivir led to Ms. Stark's instability and death, and that Dr. Lutzer did not obtain informed consent, we also respectfully ask this court to direct their attention to page 8 of the moot package and note that neither remdesivir nor informed consent were at issue here today, and thus our factum and submissions have been tailored to the issues as noted. And similarly, while we wish to respond to our friend's claim that the delay in Ms. Stark's transfer contributed to her death, we respectfully note that the transfer was also not at issue before this court today, and so our submissions have been tailored to those issues. While these potential breaches of the standard of care were not at issue today, any argument linking our friend's negligence claims to Ms. Stark's death rests on the strength of evidence in support of ivermectin. The World Health Organization, Centers for Disease Control, National Institutes for Health, Health Canada, and many others agree that ivermectin has no proven benefit for COVID-19 patients.
So counsel, that might just be because those agencies haven't had an opportunity to review new and emerging evidence. And I note that your friends in their factum on page 43, so this is the appendices that they had at the end of the factum, include a study that suggests that ivermectin may in fact be beneficial. And so I think that it goes back to this question, where there's scientific to be involved in this, and why, and I take your point about informed consent, but why shouldn't there be a conclusion of negligence where a physician refuses to adhere to the express wishes of the patient?
Thank you for your question. To that point, I believe, I'd have to check the page of our factum, but we do, we cite a handbook by the College of Physicians and Surgeons of Canada, I believe. It was in the section on the standard of care. And it refers directly to the fact that just because a patient requests a treatment, the physician is not obligated to prescribe that treatment. And our position on that is that this point is taken to the next level when that treatment that's being requested is experimental, has these public advisories against it. It is, in our submission, it is widely regarded as an unproven, a conspiracy theory linked treatment. It's received a lot of bad press, and therefore, from the position of Dr. Lutzer, this would be a very dangerous treatment to prescribe his patient on the basis merely of her request. And that prescribing ivermectin or Math Plus, in fact, could have found him in breach of the standard of care, was our submission in our factum as well. And so while there is obviously an obligation to do research and prescribe the best evidence-based medicine, in this case, the literature relied upon by our friends is widely discredited. It is based on poor science. It is in disagreement with the wide body of medical opinion. And the literature that we submit should be relied on and is relied on by medical professionals across Canada comes from the sorts of publishing bodies such as Cochrane. They publish systematic reviews and meta-analyses. And as an example, Cochrane's conclusion on ivermectin is that it may actually do more harm than good to COVID-19 patients. So just because there is some evidence out there does not mean that it should be relied upon, because it is neither peer-reviewed nor accepted by the wide body of opinion. Thank you. And so I'll just wrap things up if you don't mind. So the literature that was sent to Dr. Lutzer by Dr. Strange, it is not actually peer reviewed. And Dr. Titchener actually notes in his examination at paragraph 35 that the publisher of that study has had other studies retracted on the same topic because they falsified mortality data in an effort to make Math Plus seem effective. And so our submission is that there was no requirement for Dr. Lutzer to have relied on that sort of research. And furthermore, it could not be used to establish causation of Ms. Stark's death. But just to wrap up my arguments, in closing, we submit that this court should not find Dr. Lutzer or West Valley liable for Ms. Stark's death. We submit that the standard of care at hand was that of an ordinary specialist in the same field as Dr. Lutzer, possessing a reasonable level of knowledge, competence, and skill. By keeping abreast of evidence-based medicine and continually reviewing the hospital's treatment plan, we submit that Dr. Lutzer met the standard of care at all times during his care of Ms. Stark. We submit further that Dr. Lutzier consistently acted in conformity with a respectable body of opinion at all times during Ms. Stark's treatment. This treatment was backed by credible, peer-reviewed scientific literature, and at all times, Ms. Stark was provided with the best treatment available by Dr. Lutzier. On the issue of causation, we submit that our friends have not overcome the burden to prove that Ms. Stark's death would not have occurred but for Dr. Lutzier's actions. We submit that her condition would have continued to worsen regardless of any intervention, and therefore Dr. Lutzier did not cause her death. Finally, regarding vicarious liability, we submit that Dr. Lutzier's relationship with the hospital at the time he cared for Ms. Stark was one of a contractor. And we further submit that he was acting outside of his employment contract at the time he treated Ms. Stark, and as such should be treated as any attending physician who responded to the call to treat COVID-19 patients in an emergency. Subject to any further questions, that concludes our submission, and I thank you for your time.
Thank you. The court now invites counsel for the plaintiff to begin their optional 3-minute rebuttal.
Thank you. So first, to address again, we have this claim that because bodies such as the FDA and CDC claim that one course of treatment, that this is the proper way, and the idea that math and ivermectin contradicts this, and therefore it's not to be used in this context because it's detrimental. It doesn't help. I think when we need to be cautious, and I ask the court to be cautious when we view these bodies' claims, because we should not hold them to be infallible. I think history can really support this idea that if we think about, and I apologize for my pronunciation if it's wrong, but thalidomide, I think I'm so sorry about the pronunciation, but this was like a drug that women used back in the day when they were pregnant for nausea. And this was widely regarded and respected by and approved by health administrations of the highest standard. And then they come to find out that it's incredibly detrimental to babies, and they've left with deformities and death of children. But then again, the high standard of that time said that was a safe drug. And I think we need to be cautious about the infallibility, because as in a novel situation, as we gain more research and more understanding, we learn to develop better solutions of care. So we shouldn't just hold one truth to be the only truth. One idea. Yes.
I'm going to stop you there, but back in the early 90s, wasn't the HIV cocktail controversial and unreliable at the time?
I don't know too much about that specific scenario, so I do apologize. So I don't think I should comment on that. Yes. Another point that I think we would like to address is regarding to the expert evidence of not really holding it to be reliable. I think, again, it was brought up by one of the justices in stating that, expert evidence is what the courts rely on in this time. This is what we use to kind of reach this decision. And in the idea of, when they refer to Frazier, that the judge overruled this idea about the implicity of it was about statistical correlations, that there are not enough to make a finding of causation. We're talking about the treatment here, and where we saw anytime ivermectin or math was used, she showed signs of getting better. And so that in that, we think that's where it differs.
I've got a question for you. I didn't have a chance to ask earlier. So you state in your written argument, paragraph 20, that Dr. Lutzier agreed that the standard of care was to review research studies provided by a colleague. Yes. If that's a breach of the standard of care, what did that breach cause?
By not reviewing those studies, for him, he based his judgments on the studies that he had read, and that's what had helped him form, the hospital protocol when he had worked with his hospital. So in his eyes and by his statements, it is reasonable to assume that he reaches his judgments based on what he reads, on the articles he reads. And by not reading those, he wasn't able to form a full judgment on the use of ivermectin in this circumstance, because he neglected to read them. Since he's so heavily reliable on the use of medical research in order to make his judgments, then why couldn't he apply it in this context as well?
And so the plaintiff's argument is, if he had read the studies, he would have he would have seen that ivermectin could be reliable. Then he might have then provided ivermectin, then prevented her death. That's the sequence.
Yes, he could have reached a conclusion, at least to better explain, this is why I'm not using it, and maybe even and to utilize it. I mean, he didn't. Again, it's very subjective. We don't know what he is going to do. It's an assumption that we cannot be making, but at least he would have, have given an opportunity, and then there could have been discussion on whether he wanted to provide that care or not. And then the further discussions, if another doctor was there who wanted to provide that care, and that was the patient and the family's choice, then he could have transferred and removed himself of that from that scenario. And before I end, I do want to provide clarity in one matter when it comes to remdesivir. At least on our stance, and maybe we didn't convey this properly, and I apologize if we didn't. We don't blame remdesivir as the cause of her death. We just use it to show a compound on the standard of breach of how he breached the standard of care in multiple circumstances, and it just kind of compounded onto that. It wasn't what we claim to be the cause of her death. And that's all my submissions. Thank you.
Thank you, everyone. This now concludes the matter of Stark and Lutsier.